Assalamu alaikum wa rahmatullah. Ahlan wa sahlan, markaban bikum. A warm welcome to everyone who's joined us for this session. We are so delighted to have everyone on seat this evening. What a wonderful, wonderful number of people who's joined us in this session. We have people that I can see from Zimbabwe, Malaysia, India, South Africa. We have people from Indonesia. Alhamdulillah, we have a global group of participants this evening. I just want to welcome you to our session this evening. My name is Noorene Salie. I will be the moderator for this evening. And this evening is all about honoring and showing participation and support in the context of National Wills Week. So everyone's received an invite, everyone's joined us. We're happy to have you here. One of the things we aim to do for this session is to create an awareness about ensuring that we have things like our wills in place. We'd like to ensure that people have a thorough understanding about issues that affect our estate planning. And we also want to make sure that there are proper understandings of how we go about doing our estate planning. So for this evening, we're going to be talking a lot about estate planning, wills. We're going to be talking a lot about Sharia and the legal aspects and components of these pertinent topics. And some of the things that will emerge from the session will be things like why estate planning is important, what happens, or the necessity for us to understand the impact of death without a valid will, religious debts, pitfalls that we can avoid, provisions for estate expenses, Waqfs and gifts through your will. So all of those are some of the themes that will emerge from the discussions. But before we get there, I just wanted to do a few house rules as the moderator of the session. It's important to manage a big group that we have this evening. Just to give you a little bit of some of the house rules that we have in place for you this evening. So you might have noticed that this evening you are muted. We are going to keep you muted for the duration of the session. We're going to ask you if you have any questions to kindly use your chat box. We'll be facilitating that chat box, looking at your questions, and we're going to then facilitate the answers through some of our speakers this evening. We're also going to keep cameras turned off so that we can maintain our bandwidth and also so that we have no or less distraction on our session when our speakers come up and are spotlighted. And then just something very important I want to allude you to is the social media networks that Awqaf has put up and will be putting up. We're going to be having this session. It's a live streaming session that's going to be broadcast on YouTube. It will also be broadcast or streamed on Facebook and Instagram. And we'll be able to share this with you guys at the end of the session as well through links as well as through your emails. So this evening's session will be live streamed via the Soak Islam platform. And I will share, and my technical team will share the link with everyone in the chat box. So look out for the chat box. We're going to be having a lot of interesting links placed there. I see it's placed in the chat box already. So if you're not having good connectivity, please feel free to join us via live stream with the Soak Islam platform. Again, just a warm welcome. I want to repeat my name for those who are just entering the session now. Again, my name is Noorene Salie. I'll be your moderator for this evening. Part of what I've been doing has been working with Awqaf for the last 12 or so years. And as part of a proud supporter of Awqaf, I have had the privilege to work very closely with some of really networked individuals on this platform. And so without further ado, I want to introduce you to some really influential and some really honorable speakers that we have for tonight. And we're going to look at an overview of the program a little bit later. So our first speaker that I'd like to introduce you to, our esteemed guest, is none other than Dr. Sheikh Muneer Abderauf, hails from Cape Town, an academic at heart, who holds multiple LLBs, LLMs, LLD degrees, both in South African law and Islamic law, amongst others. Dr. Sheikh Muneer Abderauf is a doctor, he's an alim, he's a lawyer, he's a lecturer. He has many, many, many different roles that he performs and fulfills. So a warm welcome to Dr. Sheikh Muneer Abderauf. We look forward to speaking with him as our guest speaker and taking great insight away from some of the things that he will be sharing with us this evening. We also want to introduce to you our second speaker, who is Brother Zeinoul Abedien Cajee. who absolutely needs no introduction, is the flag bearer for Awqaf South Africa, is a chartered accountant and founding member and CEO of Awqaf South Africa. And Brother Zeinoul will focus on talking to us all about Waqf, Wasiyas, Habibas, and all the interesting aspects that are related to our topics that we have for discussion. Our third speaker is renowned Brother Showkat Ali Mukadam, who has a BComs Honours in Taxation, is a chartered accountant as well, has many, many different roles in terms of a trustee, a director, a deputy chairperson of South African National Zakat Fund, whom we're all familiar with as South Africans, and also a founding member of the Fiduciary Institute of South Africa. So Brother Mukadam will share with us areas that are aligned to financial planning, trust services, and we'll also deal with aspects that are related to Sharia, concepts of wasiya, key features of estate planning, as well as features of a Sharia inheritance, which we so desperately need to understand. Critical conversations. So without further ado, we are running on time. We have a lot of questions that has already been pre-posted to us that we want to get through this evening. We're going to run this event in such a way that we allow our speakers 20 minutes of airtime to just give us an understanding on some of the questions that we'll be asking them. We'll have some deep dives into the conversation with them, and then we'll open up the session to some questions and answers from the audience. Feel free to use, again, the chat room so that we can get your messages there, and we will definitely use that to position some of the answers. And then we'll take it from there and we'll see how we go. If we don't finish in time, please don't despair. Everyone's emails are on board, so we will definitely give you guys an email with all your questions that have been answered. I see the list is growing, the entries, number of guests that are entering is growing. Such a wonderful turnout. Thank you, everyone, for joining us. But without delaying the session, I want to go straight into introducing our very first speaker, Dr. Sheikh Muneer Abderauf. Dr. Abderauf, I want to thank you very much for sharing the screen with me. Welcome, a warm welcome. We hope that Cape Town is treating you well and that it's warmed up really well in Cape Town as it has in Johannesburg. As we continue through this discussion, before we can get started into maybe just getting a sense of more guidance from you, Dr. Sheikh Muneer, I want to just ask a question. I think it's a burning question that has been on the mind of a number of people that has sent through questions, and that is really about the legal frameworks of inheritance and how they relate or compare to our Sharia frameworks. And I'm sure your presentation is packed with a lot of information, so maybe you can just take us through some of the layman terms and layman understanding of the process of wills, religious debts, wasiyas, inheritance, and give us an understanding of how these all fit together and how they work for us as laymen, people who don't have any broad or in-depth Islamic basis or understanding of the complexities that exist within the legal frameworks as well as the Sharia frameworks. Doctor, can you hear me? So I think we have some network issues on Doctor's side, and Doctor will join us again. Maybe what we can do is move on to the next. Maybe we can move on to the next speaker, Brother Zeinoul. Can I bring you in here on this topic that is so pertinent? Now, we know that from a perspective of inheritance and estate, sometimes we want to leave waqfs, we want to be able to donate some of what we have. What are some of the processes that are involved in us being able to share our inheritance or leave it as a waqf? Maybe you can just start from that point and we can then join Doctor a little bit later.
Okay, Jazakallah khairan, Sister Noorene, and Assalamu alaikum to all the guests out there and all the wonderful participants that have joined us here tonight. I think it's quite an important issue that you've raised, and it's an important issue for estate planning as well, and in particular when one has to think about assets that we have and assets that we'd like to share with others, that we'd like to gift as gifts to others, and assets that we'd like to gift to Allah. So when we talk about waqf, then we're really talking about a waqf or a sadaqah jariyah that we would love to leave as a dedication to Allah subhanahu wa ta'ala and as a means of getting closer to Allah subhanahu wa ta'ala. Those are the fundamental purposes for which one would actually take some of our assets and leave it aside, give it away during our lifetime, or it could be done through our wills. So I'm going to talk about what we can do during our lifetime and what we can do through our wills. So there are three aspects that one should really be concerned about. One is the waqf. The second one is the hiba, and from my understanding and from my interaction with a lot of people, many people don't know about this really beautiful concept of the hiba that one can actually use as a mechanism for our estate distribution. And then, of course, we have the wasiya, which is the part of the will, the written will, that we leave aside something as a gift or as a waqf for either people that we care for or love or an organization. So let's just talk firstly as far as the waqf is concerned. So the waqf by definition really means to stop our own ownership of an asset. So if we stop our ownership, then who is going to be the owner? Technically, the owner is now Allah subhanahu wa ta'ala. So when I dedicate something as a waqf, I'm actually removing the ownership from myself and giving it over to Allah subhanahu wa ta'ala. But I need somebody to look after it. So I need a trustee. So I could donate it to an organization such as Awqaf South Africa, or I could actually open up my own trust and leave it inside there. If I donate it to a public benefit organization such as Awqaf South Africa, I would also get certain tax benefits. So that's quite an important issue. If I leave a waqf for an organization, whoever are going to be the beneficiaries, it could be a mosque, it could be a madrasa, it could be a family member, it could be a spouse, it could be parents, it could be literally anybody, or something that we are passionate about. So during our lifetime, we could actually do that, and we could also do it through our wills, through the wasiya portion. By the way, if we don't have any heirs, then we could actually donate the entire our entire estates as a waqf, since there is no heir. Because if we don't have a will and if we don't have any heirs, it actually goes to the state. And I'm sure nobody would love our assets to be taken over by the state. So again, it's important to have this consideration that we ensure that our assets are devolved in a way or distributed in a way that the beneficiaries will benefit. Another important mechanism is the hiba. Okay, so the hiba is actually a gift that one would give to any person or institution, similar to a waqf. But the waqf is actually given to Allah for the pleasure of Allah. The hiba is a gift given to a person for the pleasure of that person, actually, and for the benefit of that person. So there are certain rules and regulations around the hiba. I should be the owner of whatever I'm giving away. If I give something away, I need to transfer it over to that person. I can't take it back once I've given it away. And I could do this during my lifetime, or I could do it through my will. So if I do this during my lifetime, I could literally give away everything, all my assets during my lifetime to my children, to my sons and my daughters. I can give it to them equally. Some of the questions that have been raised during the registrations were also about this issue about if I have sons and daughters, can I distribute it equally? Yes, you can. If you during your lifetime, it's very possible to actually distribute your assets to your children. To secure your children or to secure your wife, or vice versa as well. Sometimes our sisters also have a lot of assets. They can very well look after their husbands as well. So the hiba is really one of a very, very important mechanism, especially if one has to plan our estates during our lifetimes. And this is a recognized system. In Malaysia, it's very, very popular. I believe in South Africa, not so popular. But I think that if we study this, and I think our ulama can give us more and more information. There's lots of literature around this that one can actually obtain. Lots of research being done on it as well. If you look at why should one actually use this hiba system, and if we look at it, there are many reasons why one could actually go into the hiba system. For example, if you look at a couple that may not have or may not have children, or a couple that there may be a polygamous marriage, for example. So in that case as well, you would have to be able to distribute your assets equitably. Otherwise, on death, your 1/8 that goes to your wife will be shared by all your wives. So I think that's also something that people who are in polygamous marriages need to consider. If you have mentally disabled children, or you have children with disabilities, it's something that you need to think about, and maybe the hiba can work for that as well. If you have sons and daughters, like I said, you could actually allocate and gift it to them equally during your lifetime. Now, the one question that will come up is, well, do I have to do the actual transfer during my lifetime? Because that's something that may have a cost implication and so forth. So one of the conditions about the hiba is that the transfer may be done upon death, but there needs to be an agreement. There needs to be a proper document, a hiba deed, that will actually enable you to ensure that your intention is quite clear as to why you are doing this and to who are you donating it to as a gift, because it's a gift of love. It's not a gift of just out of any ulterior motive. You want to ensure that the issues of justice and compassion are kind of covered in whatever you are doing. So you could now do this during your lifetime, or finally you've got the wasiya. So the wasiya, we are told that we could use about 1/3 as a maximum that one could actually leave to our not actual Quranic beneficiaries, but to other beneficiaries, to friends, to family, to organizations. So you've got that 1/3 allowance, and in fact, that is really your will, because the other 2/3 is Allah's will, because Allah has determined those other 2/3, that 2/3 portion. So that 2/3 portion is almost like what we would call intestate succession, because we've got absolutely no control over the 2/3. What we do have control over is the 1/3. And this is where our wishes and what we would like to do, we would like to donate to an institution or to a person, a family member, an adopted child, people that don't automatically inherit through the Quranic system. You can make an allowance for those people. You may have a poor auntie or an uncle, and you want to leave something for them, or you may want to leave something for a very honest and honorable employee. You may do that as well. Or you may leave something for animal care or welfare as a waqf, or that's where you've got this opportunity to actually distribute something, apart from what you've now distributed during your lifetime, you can now distribute through your wasiyah. I think I'm going to just stop there. And if there are any questions related to this, we will entertain them later, inshallah. Jazakallah khairan.
Jazakallah so much, Brother Zeinoul. That's such an interesting thing. I think when we talk about the waqf, we're talking about the gifting, the wasiyah, we're talking about different types of gifts. And I think that's something that people don't often realize, is that gifting is such an important aspect of us being able to continue to share with others even after our demise. But we'll come back to that a little bit later, and we'll talk to you shortly again on some of the questions that we might have that's coming in. So just for now, I want to go back again to Dr. Sheikh Muneer Abderauf. I believe he's back with us. Okay. Doctor, thank you for joining us again. So just give us the rundown in terms of the legal frameworks versus your Sharia frameworks, and then give us an understanding in layman's terms about how do we understand and how can we understand the process of wills, religious debts, wasiyahs, inheritance, and all of those beautiful things that we so often don't realize are critical when we're talking about our wills and inheritance, etc. If you can share that with us.
شكرا. بسم الله الرحمن الرحيم. الحمد لله رب العالمين، والصلاة والسلام على أشرف المرسلين سيدنا وحبيبنا ومولانا محمد صلى الله عليه وسلم وعلى آله وصحبه أجمعين. Yes, shukran for that question. And basically my presentation will be just that, looking at how the estate of a deceased Muslim should devolve in terms of the Islamic law of succession and administration of deceased estates. So inshallah, in order to facilitate my presentation, I will be making use of an example. So when a person passes away, that estate left behind by that person prior to any deductions could be referred to as the gross estate. So that includes everything. It includes books, includes cars, money in the bank, money under the bed, your desk, your whatever you have, that forms part of the estate. Now, in terms of the Quran and the Sunnah of the Prophet Muhammad sallallahu alaihi wasallam, there are primary verses in the Quran that governs and dictates as to what should happen to that estate. Starting with Surah An-Nisa, right at the beginning of this program or broadcast, we've looked at the recitation of ayah number 11, verse number 11 of Surah An-Nisa, where Allah says, يُوصِيكُمُ اللَّهُ فِي أَوْلَادِكُمْ. Now, there are 3 verses in the Quran. If you open up the Quran right now, or later on, chapter 4, verse number 11, verse number 12, and verse number 176, you will find the laws governing the laws of succession, or Islamic law of succession and administration of estates. In terms of verse number 11, Allah explains how the children, the descendants inherit, how the parents inherit, exactly what their portions are. If we go to verse number 12 of Surah An-Nisa, Allah speaks about the inheritance of surviving spouses, the widows, the widower. And Allah also speaks about the inheritance of uterine siblings. As we know, there are different types of siblings. Some brothers and sisters share the same father and same mother. Some share the same mother only, where others share the same father but different mothers. Now, in terms of ayah of verse number 12, it refers to the inheritance of uterine siblings, the same mother but different fathers. As far as 176 is concerned, they're looking at the full siblings as well as the consigned one siblings. So when a person looks at the distribution of the estate, the gross estate, it is governed primarily by these 3 verses. Now, the first claim against, let's say the person passes away with an estate of R1 million. And many people, they have a house and the house is worth R1 million. The first claim against that estate, prior to any deductions, prior to a son coming and say, I want a car, or the daughter coming and saying, but I want the things in the kitchen, or I want the car as well. Prior to that happening, there are certain claims against that estate referred to as liability claims. And that includes the janazah expenses. We must ensure that the person is buried first, paying for the shroud or the kafan, paying for the whole and other administration costs to ensure the person is buried. That would be the first claim against the estate from that R1 million. Now, thereafter, also as part of the liabilities, we must ensure that the debts are paid. As Allah subhanahu wa ta'ala says in the Quran, in Surah An-Nisa, in chapter 4, verse number 11, Allah speaks about the inheritance. And Allah also speaks about the bequest. But He says that only applies and only comes into force after all the debt have been paid. Now, when looking at debt as a liability, we find that there are 2 types. There's a normal debt by the creditors, be it by Edgar's or by Woolworths or by any person that we owe money. And that has to be deducted against the estate, and that person must be paid before any types of inheritance is looked at. There's also something referred to as a religious liability or a religious debt. So a person might have not performed, for example, the obligatory Hajj. Now, in terms of the Shafi'i school of law, which is different to the Hanafi school of law, the Hanafi school of law basically says that if a person has any outstanding zakah, if the person has any outstanding, did not perform the obligatory Hajj or the Hajjatul Islam, that is not deducted as a liability against the estate automatically. However, in terms of the Shafi'i school of law, which is different to the Hanafi that says it's not a liability, the Shafi'i school says it is a liability, and those religious debts must be deducted from the estate prior to any other claims, as far as testate succession claims, which is also referred to as the wasiyah, as well as the intestate succession claims, that is also referred to as the mirath. So these religious liabilities are important to be paid, especially if you are a Shafi'i. And how we can do that within the South African context is that we must state in our will that in the event of our demise, that the executor that you have appointed must then ensure that all your religious liabilities have been seen to. And it can be further stated in the will that the executor of your estate that you have nominated and subsequently been appointed by the Master of the High Court must then go to an Islamic institution. Here in the Western Cape, it could be the Muslim Judicial Council. In other parts of the country, it could be other Islamic judicial bodies. And that Judicial Council would then draft a certificate stating exactly what these religious liabilities are. Once that has been settled, so let's say all the liabilities, including the funeral cost, including the administration cost, the debt owed to individuals, as well as the religious liabilities, they have all been deducted. And let's say it is 100,000 Rand in total. We're now sitting with a 900,000 Rand. Now, in terms of the Quranic verses I've referred to earlier on, it then says, مِن بَعْدِ وَصِيَّةٍ يُوصَى بِهَا أَوْ دَيْنٍ, that the mirath, the inheritance, or the compulsory inheritance, is deducted from that estate, from the million Rand, after the wasiyah and after the debt. So now we've deducted the debt. So now I'll look at the wasiyah. What is the wasiyah? The wasiyah is also referred to as an optional succession claim, which basically means that a testator, you and I, we have the option to bequeath up to a maximum of a 1/3 of the net estate. That is the estate after all liabilities have been deducted. In this example, it would be 300,000 Rand, because 1/3 of 900,000 Rand is 300,000 Rand. So we can bequeath up to that 1/3 in favor of any person that does not inherit as a compulsory beneficiary. So, for example, if I were to bequeath that 300,000 Rand, if my gross estate is 1 million and 100,000 Rand deductions of liabilities, I can bequeath 100,000 Rand, 200,000 Rand, and up to a maximum of 300,000 Rand in favor of the local masjid, because the masjid does not inherit by way of compulsion in terms of the Quran and the Sunnah of the Prophet Muhammad sallallahu alaihi wasallam. So these are the two restrictions as far as freedom of testation is concerned. Within the South African context, we have this almost like a total freedom of testation. We can bequeath everything towards whoever. But within the Islamic context, we can bequeath, but up to a maximum of 1/3. And that 1/3 cannot be bequeathed to an inheriting compulsory beneficiary. For example, if a person passes away and leaves behind a son, a daughter, a mother, a father, and a widow, that is now the wife, all of these persons are compulsory beneficiaries. As long as they're not disqualified, for example, they are of a different religion, or they killed the deceased, and so forth. If there are no disqualifications, they will inherit by way of compulsion. They are compulsory beneficiaries. And because of this, it is not then allowed for you to bequeath something to them which is extra. Like Allah in the Quran might say that if you have a mother, a father, a son, a daughter, and a widow, the mother would inherit 1/6. The father inherits 1/6. The daughter and the widow inherits 1/8. And the remainder is shared between the son and the daughter in the proportion of 2:1. That is per Quranic injunction. So that is what is stated there. So I cannot take of that 300,000 Rand and give it to my daughter, or give it to my wife, or give it to my father or mother as a bequest, as a wasiyah once I've passed on. It is not allowed as a general principle. However, it is, however, allowed to do so if they all consent. So if I say I would like to give my daughter another 200,000 Rand of my net estate, which is the estate after I deducted all my liabilities, which is now the 900,000 Rand minus, now making a bequest of 200,000 Rand in their favor. That could work on condition that at the time of my demise, my mother, father, my widow, and my son as well, they said, no, that is okay. Because the Prophet ﷺ said in a hadith, فَلَا وَصِيَّةَ لِوَارِثٍ إِلَّا بِإِذْنِ الْوَرَثَةِ. There is no bequest, there's no optional succession or benefit to a person who inherits by way of compulsion, except in the event where the waratha, the compulsory beneficiaries, consent thereto. And a third point to note as far as that is concerned, that the bequest should also be something which is allowed in terms of Islamic law. So we can't, for example, a very drastic example would be, I say that the people should buy some wine and give it out at the local masjid. So it's not allowed for Muslims to drink wine, so therefore that type of a bequest would not be permissible. But however, sometimes you would like that at the time of your janazah, at your funeral, you'd want people to eat nice, and you want them to maybe have some spaghetti or prawns and whatever it might be. So you can make a wasiyah, a bequest, that when you die, that they should take 10,000 rand of the money available, because it can be up to 300,000 rand if that is your latest estate, and you buy some food and give it to the people who have come to the janazah, and that is permissible. Right. So that is the optional succession claim, the bequest made in favor of any person who does not inherit by way of compulsion. So let's say the person gave away the maximum of 300,000 rand in favor of the local masjid, which means that we had R1 million, we deducted the funeral expenses and so forth, all the liabilities, leaves us with 900,000 rand net estate. We've deducted the 300,000 rand bequest in favor of the local masjid, and now we're sitting with 600,000 rand. Now the 600,000 rand, that is when we're looking at what we refer to in Arabic or in the Sharia as the mirath. The 1/3 bequest, that is referred to as the wasiyah, right? And we have looked at a brief analysis of that. The mirath basically is when we're looking at who is inheriting from that estate by way of compulsion. So you can't disinherit these people. In my example, I said, the person passes away, leaving behind a mother, leaving behind a father, a son, a daughter, a widow or a widower. All of these persons are entitled in terms of verses number 11 and 12 of Surah An-Nisa of chapter 4 to inherit by way of compulsion. So that's 600,000 rand. We don't have a say. So we can't really say that I would like my daughter to get the book and the son to get the car and this one to get that. It won't really work. However, what you can do is, before you pass away, right, you can give the car to your son, and it's his. You can transfer it onto his name, and you can ask him, maybe can you lend me the car, and you can drive the car. When you pass away, it was basically the car that you loaned from your son, and that is basically a way around some of these things. The same with a house. You can transfer the house onto the name of your son or your daughter for whatever amount of money, and he can then give you a lifelong use of right later on as a gift to you if he so wants. So there are many mechanisms around working with the estate of a person, either while you are alive, but once you pass away, then these laws would find application. And the benefit of having these type of seminars is that once you know exactly what is going where and so forth, then you can play around with your estate and do what is allowed within the conforms of Sharia. You can give a gift, as was stated earlier on. You can make a bequest, as was stated earlier on as well. But however, to make sure that when you pass away, that everything is Sharia compliant. So the last question, what happens if you have not drafted a will? That basically does what I have stated now, ensuring that all my liabilities are paid. An example I could have mentioned at the beginning is that, let's say you haven't paid your dower, also referred to as a maskavi or the mahr. Right? If I said to my wife, I'll give you my house as a dawah, and I'll pay it to you in the next 10 years or 20 years. If I've not done so, then she can claim that as a liability. Right? It's not inheritance. Right? And even during the marriage, there's nothing that prevents the parties, the husband, to say, I'm going to increase your dawah, your maskavi now. So it was 10 rand at the time of our marriage, but now making it 1 million rand. So if I die, you can claim the 1 million rand because that is the arrear dawah. Obviously, as long as mutual consent by both parties, and it would also apply in the event where there is a divorce. So it's not something we're playing around with, but it's something which is real. So what happens if a person passes away, and he passes away without a will? It would then mean that neither the liability laws, like, for example, looking at religious liabilities, it's not automatic in terms of African law. You can't claim via the master's office to claim money for a hajj or to pay zakah. It won't be accepted, so it will be problematic. You have to draft that clause in the will. The same with the optional succession claims. In terms of South African law, the document must be in writing. If it is not in writing, it is not enforceable. So Islamic law allows for you to state something in front of people and just witnesses, and it would be enforceable in terms of Islamic law. But to give effect within the South African context would be problematic because it must be a document reduced to writing, and that document will then be also shown to the Master of the High Court. So therefore, for South African Muslims, it would be incumbent then to, yes, make the wasiyah, make the bequest, but also ensure that it is compliant with Islamic law principles. If that is not,
I'm going to stop you there just for our timing purposes. I think it's a beautiful topic. It's something that we can spend probably 3 other sessions or 4 other sessions on. And we want to get more on the context of the different laws from Sharia as well as Islamic law. And we have a few burning questions that we do want to ask you as well that is related to the concept of there is no will for heirs. But before we go to the questions that we have there, I want to bring in Brother Showkat here, and I want to talk a little bit about the topic around planning for our estates, such a critical issue that we need to be talking about. I think when we think about estate planning as an ummah, we don't often give due diligence to the time we need to be able to plan for these things. And I see that a lot of the pitfalls or a lot of the problems in families come about because we haven't taken the time to plan. So I want to quickly get, your take, Brother Showkat, on what is it that we should be thinking about when we're planning for our estate? How should we go about it? Where do we start? Where does it end? And what are some of the issues that we will come up against that we need to be aware of?
Bismillah ar-Rahman ar-Rahim. Alhamdulillah Rabbil Alamin. Wassalatu wassalamu ala ashrafil mursaleen. Sayyidina wa nabiyana Maulana Muhammadin wa alihi wa sahbihi ajma'in. Respected colleagues and Sheikh, Assalamu alaikum wa rahmatullahi wa barakatuh. It is indeed a pleasure to be part of this panel, and I want to express my sincere thanks to Awqaf for facilitating this in this World's Week. There's no doubt the concept of will is very important, as Sheikh already relayed all the verses really, but more importantly, in a hadith related in Muslim, the Prophet ﷺ said that you should not sleep 3 consecutive nights without having made your will. And further other hadith, we are encouraged to learn about the concept of mirath or concept of inheritance. So it's critical to our deen and it's critical to our being itself, really. Now, in a recent survey done by a leading financial institution, they've indicated that about 44% of economically active people have actually reviewed their wills in the last 18 months in this pandemic environment. However, isn't even attended to it, really. establish and firm up on why people believe really is simply because they think they don't even want to think about death in many cases, and at times it's just there's a lot of apathy about it really. So the first point is a simple will is a part of a plan really, and that's the starting point really. A simple will is part of a plan, and the first thing is to make sure that you have a will and that the requirements of a basic will have been met. Namely, that anybody who has any asset and that's older than 16 should have a written will. It can be either typed up or it can be written, really. And as Sheikh said, indicated early on, in an Islamic environment, if you do announce your will, in fact, you don't announce any will in an Islamic environment because by default, the Quranic verses apply. Your will only applies to the wasiya. Those are the kind of 1/3 items you would want to give. But within the South African context and within the Wills Act, your will has to be in writing. That's the first point, okay? The second point is that you as a testator must sign every page of that will. Third point is there must be 2 witnesses who witness you sign that will. In other words, you can't sign the will and then go to the witnesses afterwards. That's not a valid will, effectively. And fourthly, the witnesses can't be any heirs in that will. Very important. Often we find that the will is signed in the house and the heirs who are going to be inheriting are witnesses. They are then disqualified as heirs. The will is not an invalid will, but they are actually disqualified. And the issue in a Sharia will is that your extended family could possibly, in a remote chance, be the inheritors of your will, of your assets. Your extended family, in other words, you all go down in a plane and your whole family, your immediate family is wiped out, then the extended family do come into play and hence they could. But if they are a witness to the will, then they can't inherit really. So I think that's the most important criteria of making a valid will, and that's a good plan. You said that what is the most important clause in that will? The most important clause in the Sharia will say something to this effect. My assets are to be dealt with in terms of Islamic laws of inheritance succession, and that the proportions are to be certified by an alim. That's the key clause in your will, besides the wasiya clause. The rest of the requirements, who are the executors and all those kind of things, are the common requirements. But the most important differentiation in a Sharia will is this statement and the statement about wasiya, which have been alluded to, and which are. Now, the important point about the statement is that you do not actually say the proportions, who is going to inherit what proportions. Have you noticed that? You say that my assets are to be dealt with in terms of the Islamic laws of inheritance. And there is a very good reason for that. And the reason for that is that the heirs in your estate and the proportions determined is based on who's alive at the moment you die. Okay? So let's put it this way. Your father and your mother inherit, as Sheikh as earlier said, and they each inherit 1/6. If both of them are alive the moment you die, then they will inherit. If one of them is alive, then only one inherits. And that is why you can't spell out in the will that my parents are alive today, please give them 1/6 each. My wife is alive today and I have children, please give her 1/8. You can't say that. It has to be determined the day you die or the moment you die, and that is why an alim certifies it. So typically you'll go to the MJC and you'll say to the MJC, these are the people who are alive, and the master is going to request a certificate from an independent alim. And we know what the answer is. We know the parents get 1/6 each. We know the wife gets 1/8 if there are children and 1/4 if there are no children, and so on. We know what the answer is, but the master insists in wanting a certificate based on that moment who was alive. And therefore, the proportions and the values also change. The proportions and the values. So the first thing is that the general statement in your will. The second point about that statement is you must know your family very well. You must know your family very well, because a stepson is not a compulsory heir, it's not a Quranic heir, as Sheikh has indicated. An adopted child is not a child for the purpose of the Quranic verses, really. So the point is that when many years later, Buddha's 85 years old and he passes away, and you've actually got to disclose the facts. What is this child? Who are they? So that's very important to know the family situation very well. Two is you also need to have a sense of the proportions, really, as Sheikh has always said. So there are 12 sharers of within the verses that the Sheikh has enunciated. However, there are 3 that always inherit. There are 3 that always inherit. The spouse of the deceased always inherits. In other words, if the husband has passed away and there are children, the wife gets 1/8. If the husband has passed away and there are no children, the wife gets 1/4 of the husband's estate. If there are parents alive, they each get 1/6. If both are alive, they get 1/6 of the deceased male in this case. And the balance go to the children if there's daughters and sons on a 2-to-1 ratio, and vice versa. If the wife dies, all right, the husband gets 1/4 when there are children, and he gets 50% of the wife's estate when there are no children. And similarly, her parents also inherit, and similarly, the children will share on a 2-to-1 basis. However, I want to just highlight one particular combination that often is overlooked. That is if you only have daughters. Only have daughters. If you only have one daughter, please, participants, the daughter inherits 50% of the deceased estate, whether father or mother, for example, in this case. All right? The parents can inherit, the spouse can inherit, but the uncles and the aunts, the brothers and the sisters of the deceased inherit the balance on a 2-to-1 basis. On a balance. If there are only 2 daughters, in other words, no sons in this example, they share 2/3 of the estate of the deceased, 2/3, if they are only daughters. Again, the parents, the father or the mother will share the 1/6, and then the brothers and the sister or the uncles or aunts will share the balance. That's often overlooked because the most common one that we have is that, oh yes, there's a son and there's a daughter, and that's very easy, that's very easy. But when there's only daughters, I'm trying to highlight that the uncles and the aunts come into play to bequeath as a compulsory Quranic heir, as a compulsory Quranic. So understand the proportions very well. It's critical. The next aspect that we spoke about, and which Zeinoul and Sheikh has referred to, is the wasiyah. So the verse says in Surah An-Nisa, pay the debts, pay legacies, and then the Quranic heirs. So legacies is a translation of the word wasiyah. And as Zeinoul has indicated, you can give up to 1/3 of your estate as a wasiyah. However, the Prophet ﷺ has reported in Bukhari, think twice before you give the whole 1/3. Think twice before you give the whole 1/3. In other words, don't deprive your family. Don't be brave. Don't be gracious. In other words, you want to give 1/3 away, but you leave them with a little bit as part of the 2/3. So take care of your family. So the 1/3 can go to anybody who's not your Quranic heir, except as Sheikh indicated, unless there's consent. And that consent only happens, I presume, after death, and Sheikh could confirm that. However, where the 1/3 wasiyah is very important is when you have children who have predeceased you. In other words, if I have grandchildren of my son that's predeceased me, in many cases, those grandchildren are not Quranic heirs. They're not compulsory heirs. They're not fard heirs. Then you should have a clause in your will that if in the event that situation arises, give to those grandchildren out of the wasiyah clause, but limited to 1/3 of your estate. A very important clause, because we've had situations in our office where the grandchildren sit around the table and says, what did my grandfather do? Because the per stirpes rule does not apply in the Islamic situation. In other words, the grandchildren don't step in the shoes of the children. Okay, very important. The moment you have that situation that you have got a child that's pre-deceased and leaving children, please consult your consultant and insist that the wasiya clause makes a general coverage for them, so that in case they don't become Quranic heirs, the compulsory heirs, they can benefit out of the wasiya clause. If there is something you take away tonight, it is that principle, because for too many situations we have where the grandchildren do not inherit, and this, as Zeinoul has indicated, this creates tremendous problems in the family effectively from that point of view, right? So those were the essential important points of the differentiation factors in a Islamic world. However, another factor that's becoming common these days is that the wives contribute to those kind of costs, which is the responsibility of the husband. The wives contribute to those costs which are the responsibility of the husband. Wives out there, if you do that, record it, get it signed off every year, and that is a claim against the estate. It is not part of the proportions that's distributed. So you get your share fully paid out up front before the proportions and before wasiya, by the way. So wasiya applies first the debt, that's a debt, then wasiya applies, and these proportions that we talk about is based on the balance, not on the 100, it's after all those things. So those sisters of you who are contributing and you're doing it out of love and all those kind of things, please, in Surah Baqarah, it says, record it in writing, have it signed off. And I would even go further and get the spouse to make a statement of acknowledgement in the will that my wife has over my lifetime contributed to our costs that I am supposed to be responsible, and I acknowledge that this is a claim in the estate by my spouse, and vice versa, by the way, okay? I mean, if it is the case. But the point is that I think that's another critical differentiation. The next point I want to cover is whether you can distribute in your lifetime. There's nothing wrong. You can use a trust mechanism. You can donate to your children in a trust mechanism, grow the assets in a trust mechanism, and as long as you are fair, there is a very strong recommendation that you should be equal. It should be done equally in your lifetime. And simply that's just to not create animosity amongst the children. In other words, you gave the one already 5 million rand and the other one 1 million rand, or 1 million rand to the one. So the recommendation strongly is that you should do it on a fair basis. So the concept of a trust works very well if you're concerned that the child may lose the assets, may abuse the assets. A trust is a wonderful mechanism to place these assets in. When assets are in a trust, yours or these kind of, they're not in an estate. They don't go through a process of the estate. To wind up an estate takes about 2 years. Everything is frozen in an estate, effectively. So when assets are in a trust, you don't go through this process. 2, it's protected, very much protected inside the asset. Obviously, there is the admin nightmare about, annual tax compliance and so on. However, the trust can be framed on an Islamic principle, because at the end of the day, a trust deed is a constitution that you write. And you can announce the Islamic principles. You can announce the Islamic principle of inheritance to be applied on the deceased, when the planner deceases. Okay, so you can adjust it, and therefore assets can be held in your personal name, which ends up in an estate, or assets can be held in a trust, and you can set the conditions and the constitution of the trust accordingly, because a trust deed is a constitution. Obviously, you have to be very careful how you word it. You've got to spell it out. You've got to make it very clear that the heirs on your death are going to be those in terms of Sharia. If you don't want to do it in the trust deed, you do it in a resolution to the trustees. You do it in a letter to the trustees also. So I think the trust mechanisms works very well. And more importantly, when the assets are in the trust, it's not in your estate, and it's not subject to estate gains tax, and it's not subject to the executor's fees. However, that there is these compliance issues that you need to. So more importantly, if you believe that you got a son or a child that's very spendthrift, or you got a child that's on substance abuse, please use the trust mechanism. And you can say that in your will, I want my assets to be dealt with on a Sharia basis. However, when it comes to X, his assets must go into a trust for him to be formed on your death. And wonderfully, a testamentary trust will be formed effectively from that point of view. Then, please make arrangement for all the cash requirements in an estate. Try and make arrangements for the cash requirements in an estate, effectively. In other words, except that there's going to be fees payable to the executors, there's taxes and all those and liabilities to be paid, do not leave the problem to the heirs. Effectively, if you believe an asset should be sold because there is no cash, then give clear instructions. Do not let the heirs sit around the table and debate for hours which asset are we going to sell, because they may have emotive lines to the assets really effectively. The next important point is please communicate with your family. Indicate to them where the will is. Indicate to them who are going to be the executors. Indicate to them what your thinking is. The biggest challenge in a Sharia will is who gets what for their share. The biggest challenge in a Sharia will is who gets what for their shares. So to illustrate that point, if you got listed shares and you got a house and you got a car and you got a business and your assets are total 10 million rand and your wife must get 1250, which asset does she get for 1250? You see the problem? If the son must get 4 million rand, hypothetically, which assets does he get for 4 million rand? If the daughter must get 2 million rand, which assets? So generally, the way to overcome that, you discuss that up front. Alternatively, you say in your will, I want my assets to be dealt with on a Sharia basis. However, I recommend, subject to everybody's consent, that the business goes to my son towards his share of the Islamic inheritance. If it's more, then he must pay in, and if it's less, he gets that plus something else. Always remember, money and near money is easy divisible. Money and near money, in other words, unit trust, a car that you can sell, is easy divisible. The moment you go beyond that, you've got other kinds of assets, you should seriously apply your mind as to how, and consult a consultant, how this is going to happen. So importantly, communication is important, liquidity is important. So finally, I want to leave you with an acronym. Those of you who got a pen, you can write this acronym down. PICS, P-I-C-K-S, P-I-C-K-S. P stands for plan, have a plan, have a will, have a plan where the money is going to come from. I is information. The biggest challenge that we have in an estate is information. Where is the title deed? Where are the bank account numbers? What is the PIN number of the accounts? Okay. What's the registration number of the cars? What's your credit card number? We need information. And as you know, no estate takes less than 1 year, and it's gone almost to 3 years to wind up. If you got that readily available, then that makes life easy. Communicate. C is for the communication. I said communicate with your family. K have some knowledge of the process, have some knowledge how inheritance is going to work effectively. And finally, remember, there is a spiritual dimension to passing on the assets. It's clearly spelled out on the basis of the Quran and the Sunnah of the Prophet sallallahu alaihi wasallam. Shukran for your time, and I hope that was useful. Shukran.
Alhamdulillah, mashallah. Thank you very much. I think that was a great understanding about the importance of planning and how we should be going ahead to plan, Brother Showkat. There are some questions that are coming through. I want to encourage everyone to use their chats just to ask some questions. Brother Showkat, I just want us to have a quick question. There has aspects related to the Pension Fund Act. life policies. So if I had to just group them up, it would really be roughly about issues that are related to our tax benefit as well as our policies. And now from a Sharia perspective, we understand that life policies in relation to Islam is not permissible. And I think that Imam can also, or Sheikh can also give us some insight on that. But there are some questions where we have to sometimes entertain life policies because of work, pension, provident funds, etc. So Section 37C of the Pension Funds Act, can you just give us a sense of how does one deal with the pension benefits when it comes to wills?
Yeah, so all pension funds and provident funds and retirement annuity funds are actually managed by trustees. When you nominate the beneficiary in your pension fund, your provident fund, and your retirement annuity, that's a recommendation by you. However, the day you die, the case is presented to the trustees, and unfortunately, the trustees have the final say on the matter, really, okay? So often we have the cases, for example, of a husband got married to another wife, second wife, and there are smaller, the minor children from that wife, and there are major children from the first wife. Most likely the trustees will look at the minor children, for example, even though you said I recommend my spouse to be the heir of the pension fund. So the answer very simply is the trustees have the final say, and the case is presented to the trustees. As far as life insurance is concerned, obviously, most opinions is that, and Sheikh will contribute to this, is that it's not permissible. However, there is consensus amongst the scholars that the life insurance proceeds can be used towards the cost of an estate, towards the death cost of an estate. In other words, the estate duty, the income tax, the capital gains tax, and the executor's fees. And so in our wills, and what I recommend to everyone, is that you clearly spell out. You make the proceeds policy payable to the estate, and then you say in your will under bequest, I bequeath that the proceeds be used towards death taxes. That's the first statement you make. 2 is you then say that the contributions you've made goes into the halal pot for Sharia apportionment, because contributions are allowed to be taken out of it. And finally, if there is still a surplus after that, you recommend a charitable institution. So, for example, if your policy is, say, payable R1 million and your estate cost, total cost of all the costs of the estate is 500,000 Rand, and your contributions, you can get a certificate from the broker or the financial planner or the insurance company. They will say the contributions were 200,000 Rand, then 500 plus 200, and then the 300,000 will then be paid out by the executor too. But you've got to spell it out in the will. Otherwise, it ends up in a common pot amongst everything, effectively. So spell it out very clearly in the will from that point of view. However, most policies, and this is another important point, most financial planners make the spouse the beneficiary of the policy. And the reason for that is that when the policy is paid into the estate, it itself attracts 20% death taxes, 20%. However, if the policy is payable to the spouse, it doesn't attract that 20%. So anything between husband and wife or wife and husband is always free of death taxes, always free. Okay? So what happens in this case, the financial planner says to you, this is a great product, make the spouse a beneficiary, but you don't have to, you're not going to pay the 20%. But on what basis does the spouse bring the money back to the estate to settle the cost? There's no basis. There's no basis. Whatever she brings, there is no request on her. There's no call on her to make that. Therefore, if you believe that these costs are to cover the estate, and if you need R1 million, you actually need 1.2, because the R1 million itself is going to attract the 20%. So that's a very important point. Make the estate the beneficiary, and it will solve all the problems. And the reason, the logic for that we can use that is that simply because this is a tax imposed by the government on your wealth, and you don't want to decrease your own wealth that you've built up. You're happy to use this mechanism. In every Islamic country, there's never death taxes. There's never death taxes, really. So we're a Nasara country, and hence we got death taxes.
Okay, Jazakallah so much. That was a great detailed answer to the question. I think we can move safely into the next section, which we are going to look at is the Q&A. And to do our Q&A, we have already some questions that we have here. So I'm just going to talk about the first question that's come up. And Sheikh, I want to pose this question to you. It talks about in the Islamic succession plan, is there something like vrug gebruik? So I'm not sure if you understand that question, but a sister is asking that question. If we can maybe just get that, I am posing it to you, Sheikh.
Yes, shukran for that. I'm not basically so clear with the vrug gebruik, but I'm thinking she's speaking of the use of right. Probably, yeah. So okay. in terms of Islamic law, there is something referred to in the Maliki madhab as an umrah, and that is basically where a person then gifts by way of a gift to another person. So let's say there's a husband and a wife, and the husband he owns a house, and he wants to gift during his lifetime to his wife a lifelong usufruct of the house in her favor, and even has it registered by the deeds office. So that usage of the property will extend past his lifetime as well. So for as long as she's alive, even if she lives longer than him, she will be sorted out for the rest of her life. In the event of her passing, then that asset, that house, for example, will then be redirected back into the estate, or basically at the time of his death already, it will be redirected, but the usage of the property will remain with her for the rest of her life. And that is also a way of ensuring that your wife is sorted for the rest of her life. Or if you have a young child who would also like to give something like that as a gift, that can be done, definitely. Shukran.
Fantastic, Jazakallah for that one, Sheikh. Brother Zeinoul, I want to come and bring you in on this question here. I think that's quite pertinent to hiba. The question is, are there tax implications when gifting in terms of hiba?
Okay, Jazakallah for that question. Okay, so basically, if you're giving a gift to your wife, there's no tax implications to that. Okay, if you're giving a gift to your children, then you are allowed to give up to about 100,000 rands per annum to anybody else, to your children in particular. If you're giving a gift to a PBO, like public benefit organization such as Awqaf South Africa or any other non-profit organization which is a registered public benefit organization, then also you are exempted from any donations tax. If you're giving it via your will, if you through your wasiya, if you're giving to a public benefit organization or to your spouse, there are no taxes payable for that as well, up to a certain amount. For a PBO, it's completely tax exempt. So those type of gifts, I think, would be you'd need to actually consult with your advisor prior to that to see exactly how much of it will be taxable and how much will not be taxable. But clearly, the two entities, or the wife or the spouse and the public benefit organization or charity organization, those are clearly tax exempt. So I think when you planning your estate, think about this carefully, because it actually saves you some estate duty as well, because there's no estate duty on donations that you give to a public benefit organization or donations that the hiba that you give to your spouse. For example, it may be in the form of the claim that Showkat actually mentioned early on, which is quite an interesting one, where wives have to claim for their contributions to the cost of their running of the house and taking over the husband's responsibilities. So he may compensate her for that, or he may, this gift that he gives to her in terms of the mahr can also be construed as a debt. So, it's quite an interesting way to actually plan your estate so that you minimize your taxation as well. Thank you.
Jazakallah so much. Okay, I'm going to deal with some of these questions in batches. We seem to have a trend that's kind of unraveling here. There is a question. So Zeinoul, Brother Zeinoul, if you can stay on with me. Is there someone from Awqaf who can help to draft the will? Is there any product from Awqaf or any financial institution to cover the executors' fees, etc.? So I just want you to deal with that question for us, please.
Okay. So yes, I think after this particular webinar, we will be sending out a little service form to ask people what type of service they would like to have. For example, they would like to have a consultation, or they would like to draw up a trust, or they would like to appoint an executor, or whatever the need is. And then we will be able to recommend the service providers, relevant service providers for those particular needs. But certainly we can help them to set up the will. We can help them with the point about covering of costs. And there were other questions related to covering of either estate duty or executors' fees. So currently, there are 2 organizations that actually provide this kind of service, but it means actually taking out some kind of takaful policy to be able to cover those costs in the event of your death, and to cover whatever the pre-calculated expenses might be. So yes, those are clear possibilities. If you don't mind, I just want to mention something else that Showkat actually brought up with regard to trust for minor children. Now, you could either set up your own trust, or you could use an organization such as Awqaf South Africa to actually house your minors trust funds, because you don't need to actually create a trust and create additional expenses in managing and maintaining and complying with all those rules and regulations when there is an existing facility that one could actually use. Not everyone can actually afford to establish their own trust and manage it and all of that. So I thought I'd just mention that as well as a service that Awqaf South Africa can provide, because it is a registered trust and it is capable of managing minors funds. So one of the pitfalls that one has to be careful about is what happens to minors funds that are, or if you have any minor children, what happens to those funds? Now, if you don't have a clause in your will to say that your minors funds should not go into the guardian's fund, which the master actually controls, then you've got a bit of you've got a problem, because your minor children's money is now going to be sitting in the guardian's fund. So in order to avoid that, have the clause in your will to ensure that it actually goes into a trust. If you've got a big enough fund, then by all means create your own trust. But if you have smaller funds, it would be better to actually hand it over to trustees within Awqaf South Africa, which is a registered trust that can look after those minor funds and that can, manage those funds in a way that the executor really wants. Jazakallah.
Jazakallah so much. Since we're talking a little bit about the trusts, I think it's pertinent to bring Brother Showkat in here. Brother Showkat, questions are being asked about if you could elaborate on some of the pros and cons of us setting up a trust, what is administration costs and tax implications and impact. And then I also want to just keep you on the line for a further question with regards to the example you gave us previously. If you have daughters and how the daughters inherit, we have a question on that we can talk about after the trust fund question. If you can just come in there for us.
I didn't pick up that question quickly, but I think it's something about daughters. I didn't. The sound wasn't that good. Can you hear me?
I can hear you. So we want to deal with two questions with you. One is the one about trust funds. So how do we set it up? And administration-wise, what are the costs involved and the processes that and the impact of tax implication on a trust fund? And then the second question we'll deal with is related to whether or not, if you have only one daughter, does the residue still go to the brothers and sisters if there's a father that is deceased? If brothers and sisters, if the father of the deceased is still alive, does the father not block the deceased siblings? And does the father then not get 1/6 from the residue? So we just want you to comment on those two questions for us, please.
Yeah, so when one talks about the trust, I think the answer to that is one needs to look at very holistically. One can't just look at it from a tax angle, effectively, and estate duty and so on. I think one needs to say, listen, what is the need for this trust? What's so critical for this trust? And then work through the process. You will be able to manage and to understand what the cost is, typically the cost of maintaining the annual compliance factors and so on. But the answer to that is one needs to look at each one individually and assess it from that. So, for example, if you have a disabled child, for example, or a child that's on substance abuse, really, I mean, even if it's 2 million rand, you can't afford to, or R1 million, you can't afford that the heir gets R1 million in his or her hands under the circumstances. Are you with me? So in that situation, excuse me, I just want to get my chargers going here. In that situation, it's a very different objective to another arrangement, effectively. So the answer is there are costs. There are ways to minimize the tax also. You don't have to put all assets into a trust. You can put it into a vehicle below the trust and so on and so on. So I think the said person who posed a question should really analyze it with his consultant in this case, what the needs are and so on. As regards the inheritance, so in the case where there are two daughters, you said, two daughters, one daughter. The said heir will inherit 50%. The daughter will inherit 50%. If there's a parent alive, obviously the father or mother has died, so there is another parent alive. That parent will inherit 1/6. Okay. And then the brothers and sisters will inherit the balance of the deceased on a 2-to-1 basis. If it is brothers and sisters, or if it's just brothers, they will inherit it equally, effectively. But many of these computations, I must just remind the audience, they are wonderful inheritance calculations, Islamic inheritance calculations. You just Google Islamic inheritance calculator, and it asks you to enter who are the surviving heirs, and it gives you the answer.
Absolutely, and I think that apps are all available through some of the Muslim hands and places like that, as well as on Google. An interesting question here, Brother Showkat. I'm not sure if you'll be able to give an answer to this one, but it does ask, the sister has a house and would like to gift it to her child. What's the best option? Is it sell at minimum amount or transfer to his or her name? So I think that is more on the personal side of, what is the value of the house, etc.
Yeah, look, obviously, the reason why the person wants to gift it is, first of all, if it is done through a will, there are other heirs. So the objective is to deny the other heirs, then that can't be right. That's the first point I want to. In other words, you can donate, you can gift in your lifetime, but the objective must be very clear. Okay, so if there is one child, for example, and if it's a daughter, and as we just said, the uncles and aunts will inherit, for example. Are you with me? So if you believe that you want to donate it to the child, let's look at the challenge the other way. What happens if the child predeceases you? Okay, if the child predeceases you and has a will, then the calculation has to be done on the basis of that. So I think you need to think this through very carefully. It is not just as straightforward that I want to gift it to my child. Are you with me? And as Sheikh earlier on alluded, what comfort have you got that you still can have security of the home unless you don't live in the home, for example, unless you don't live in the home, and so on. So again, the answer is that, yes, you have to look at it. You've got to sell it at market value. There's donations tax that must apply. And again, it's not a simple answer. Again, you need to consult somebody who understands these mechanisms and give you the best answer. And I'm not sure if Sheikh wants to comment on the fact that the donation is made during your lifetime and maybe deny the heirs on Islamic succession, really.
Jazakallah. I think that's a good question, if Sheikh can come in on that. And then at the backdrop of that, Sheikh, we have another question that says, I would like to give inheritance to my son before I die. So by the time I go, my son would have acquired the majority of inheritance. So maybe the two questions are related. You can comment on that.
Shukran for that. Concerning the previous question of the house, if the father wants to sell the house for whatever reason it might be, it's not stated in the question, then if he sells it for market related price or value, which means that the money basically comes back to the father and he can do with that money as he so wishes. If, however, he decides then to have the agreement that, look, I'm selling it to you for this amount of money, I'll give you something back, but then you have to give me lifelong usufruct in favor of that as a gift, that could also be another possibility. So the pros and the cons must basically be discussed around the matter, and they can definitely come to a reasonable conclusion in that regard. The next question was?
So a similar question where the son has acquired a lot of inheritance before the demise of the parent. So how does one, by the time the parent passes away, that son would have acquired majority of inheritance already?
Okay, basically the inheritance only applies at the point of the person's demise. Then we're looking at inheritance. Prior to the person having passed on, then we're looking at maybe gifts or a sale transaction to someone and so forth. The child could have bought certain assets from the father, the car, the house, and so forth, before he passed away. So it's nothing to do with inheritance. The father can even acquire more properties later on. And sometimes you hear people speaking about that, I'm giving out my inheritance now already. There's nothing like that, because inheritance only applies, and the laws of Allah only apply as far as inheritance is concerned once you pass away. So before that point in time, then you have to look at, is it a gift? And if you're giving it to your children, and they're all okay, they're all working, they're all stable, then the right thing to do is to be fair between all of them by giving them equal shares. right, as far as that is concerned. If one, however, is a bit struggling and so forth, then you can explain that to the other children and give a gift to that child as well. But to answer the question, it's not distributing the inheritance, or maybe it is distributing parts of his estate. But the problem, again, lies in the fact that it might be that that person doing this might live for many, many more years. So he has already given so much away. And if that son dies before him as well, then that property does not necessarily come back to him. He might inherit 6 years, but it'll go to that person's spouse and children and so forth. So these factors must be kept in mind before making a decision in this regard.
Okay, Jazakallah Sheikh. Please don't go away. We want to ask you the question about, please explain if a non-Muslim child can inherit from a parent who became a Muslim. If they're not considered legal Islamic inheritors, can they be left with any wasiya? So I think it's a two-part question for yourself and Brother Zeinoul.
No.
I think Sheikh can answer that question.
No. Basically, if the family was let's say they were all Christian, right? It was a Christian family, and now the father, I believe, then embraced Islam, so he has a non-Muslim son, right? So the son, you can't force him to become Muslim. That is not a problem. As Sharia says, we can't force anyone to become Muslim. But then we look at the distribution of the estate of the Muslim father. He can bequeath up to a maximum of 1/3 of his net estate after all liabilities have been deducted in favor of that non-Muslim son. It is also possible that one of his other sons also embraced Islam. And at that point in time, he can then work around with his estate to even give his Muslim and non-Muslim children inheriting the same proportion. One inheriting in terms of maybe the laws of mirath, and the other inheriting in terms of the laws of wasiyah. But at the end of the day, they might inherit the same amount of money.
If I can just come in there as well, we just recently had a case where the father inherited from his father, but this person also had non-Muslim children, or that purportedly are non-Muslim children. But he didn't actually make any provision in his will for these non-Muslim children. So that's another thing that we have to be very, very careful about. And the other problem is that a pitfall that this person did his will maybe in 2007 and he passes away in 2021. And during this interim period, the will was never ever reviewed. So now he's got he passed away, and these non-Muslim children are disinherited in terms of the inheritance. So they basically left now with nothing. So, and if the other heirs deem it fit to actually share some of their inheritance with these the other siblings, then it may work. But who's going to do that? You know. So if it hasn't been clarified in the will, those children, be they non-Muslim, have actually lost out.
Jazakallah for that, Brother Zeinoul. I think it's a beautiful time for us to talk about some of the pitfalls and things that we can do to avoid. A lot of the times, you know, that we do estate planning in a very terrible way. We don't really pay much attention to that. Our inheritance structures and Sharia compliances, sometimes we're taking out wills through banks and thinking that it's okay to be able to bequeath certain certain assets and to our children in certain ways. We don't really have great full understanding of what we should be doing, but in correcting all of that, there certainly are going to be times when we're not going to get it right. And sometimes we are going to get it right. But what are some of the things that we need to be thinking about? What are the areas that we can avoid when it comes to things like compliance from a Sharia perspective, from an inheritance perspective, from a tax perspective, as well as from a wasiyah perspective, and also bringing in the concept of Waqf being something that we want to also leave as a legacy and something that we want to earn perpetual benefits from when we all go. So what are some of the lessons that we can take away from us with regards to these areas? What have you learned? What have you seen? What are best practices, and how do we avoid those pitfalls and close the gaps in these areas? So I'm going to ask each of the speakers to give us just 1 minute on that, and then we can just wrap up depending on how many more questions we have to take. Okay, so Brother Showkat, you are up first.
Yeah, look, for me, the most vital is communication. Really. Communication with the family, communication with the professional advisors, and so on. I think for too long, the planner does the estate plan without any kind of form of communication, and the family doesn't actually know where to start really from that. So for me, communication with the relevant stakeholders is the most critical. Communication about when the estate process can start. Communication as to when can we approach the executives for various documentation to be signed. It doesn't mean the estate is going to be handed over. And with the administration nightmare as we have in the master's office, as you know, at the moment they're down totally from an IT perspective. Estates promise you anything from 1 year to 3 years to wind up. And the later you start, the more problematic it becomes. So for me, communication is vital.
Jazakallah so much. And then just, I think there's a question that's linked to that in terms of setting up of a Sharia will. Is that something, Brother Showkat, you and your office would be able to do, Awqaf would be able to do? Or is it a daunting process, or is it something that is quite simple?
No, it's not a daunting process. I gave you the criteria and I gave you the statement that's needed in the will. However, we always look at other challenges. With me, as I said earlier on, who gets what for their share and so on. So they're welcome to contact me. I'm sure you're going to provide all the details at the end, and I'm sure Awqaf will also provide that service through their own office or a service provider. But that's what we do full time. That's what we do full time.
Fantastic. Jazakallah for that. Brother Zeinoul?
Yeah, I think that, there are several areas where people can really be, more diligent in terms of their estates and planning. So the one thing is that, first of all, I think the most important pitfall is that we don't have our wills in place. And that is, I think, probably one of the most critical areas that we all need to consider to make sure that it's all up to date. Secondly, I think that each person that makes up a will must have a nice complete file, and that file must have a power of attorney. It must have the will. It must have, if there was Showkat mentioned about the acknowledgement of debt, maybe you have those. If you've got any creditors, make a note of that. Make a note of all your insurance policies. Make a note of all your credit cards and all your telephone numbers, your PIN numbers. A simple thing like somebody passes away and now he's left with a phone, and you want to contact all his contacts to inform them that so and so passed away, but you can't access that phone because you don't even have a PIN number. So have all that nicely put into a file, and it's accessible, and your heirs or 2 or 3 people actually know exactly where those documents are. Very often, like some of the speakers have mentioned, people don't even know where to start, where to look for it. And at the time when the person dies, things are chaotic, they're hectic, people are under stress, and they're emotional. And I think it's important as part of that communication, actually, that an extension of that communication is to have all your documentation in one nice place where it's easily accessible. Of course, there are many other points, but I think let's hand it over to Sheikh now.
Noorene, could I just intervene there? And Zeinoul, I actually forgot to mention that we have an electronic personal estate document on our website that you can populate and maintain yourself if you download. So it's an electronic document that covers the A to Z, as Zeinoul has just covered. So anyone who wants to access it, they're welcome to go onto our website and download it and store it for themselves or give it to their advisor. So there is a personal estate document that covers A to Z, what's required, information, VIN number of your car, and all those kind of details.
That sounds like a very useful document and template that people could save and keep. Jazakallah so much. Brother Zeinoul, Jazakallah so much for your insightfulness on how we could actually keep some of these pertinent information as well. Certainly things we always just forget. It's the last thing, like where's everybody's ID when someone passes away? It's like, who knows? But thank you very much for that. Dr. Sheikh, your closing words on this?
Yeah, my closing remarks is basically that any person that is either young or old, you will definitely die, as we know. But in order to prepare for that point in time, and also understand your status quo, because many times a person might, for example, have a child. Let's say that the child was conceived at a wedlock. You might not know that child, if you have a standard will stating that in terms of Sharia, and it might just be that the Islamic institution doesn't provide that person will be entitled to inherit. And as a consequence to that, you could have dealt with this beforehand by drafting a clause in the will stating that he or she inherits from the wasiya. So there are ways. It might be some of our viewers, they may be married to non-Muslims as well. So that would be a disqualification in terms of Islamic law. But you can bequeath, and as a bequest in favor of that wife, so she can also inherit. So to understand all of your status quo, and then to make a decision as to what you want to do with the estate, and also with regard to debts and liabilities. So many times we're very trusting, and a person might say, no, you just take the 10,000 rand, you can sort me out again. But when you pass away, that person has no tangible proof that you owe him that amount of money, and that would definitely be some issue for you in that grave. So my advice is, as summary, is that ensure that you know exactly what your status is, and ensure that you do the best estate planning with the correct people involved. Shukran.
Jazakallah so much. Jazakallah, wise words there, Sheikh. I just want to add on to that when I looked at the topic that was coming up for discussion today, one of the things that struck me was that Allah subhanahu wa ta'ala has spoken about absolutely nothing on the procedure of how to make salah, how to perform your hajj, how to do all these 5 pillars of Islam, with the exception of wills, inheritance. The detail in the Quran is so amazing, and that was something that I thought, wow, Allah subhanahu wa ta'ala had left that for himself to discuss, and not as part of what our Prophet sallallahu alaihi wasallam taught us. So that was really something as an eye-opener to me. Everything about wills and inheritance, etc., is detailed in the Quran really, really well. So from that perspective, I think that it's really up to us to go out there, understand how to interpret, how to be able to apply that. And there are many options, as the speakers have so kindly shared with us today, how much we can actually do and think about our estates, our families, our loved ones in a very different way. But we've got to be able to start somewhere. And starting somewhere requires that we go out there, seek the knowledge, information. Awqaf is a platform that does that. Brother Showkat does that. Our Sheikh does that. You know, it's just for us to go out there and get the information. We have a few questions that have not been asked, but I'm going to leave those questions for now because we still have a closing dua that I would like Sheikh to do for us. But on that note, I'd like to say a warm thank you to each and every participant who has joined us. We've had an overwhelming turnout today. More than 230 people was on for tonight, which is not something that I think we anticipated at 3 o'clock this afternoon. We were still sitting in the high of 150 people. So this was a really, really wonderful response from the people, showing that there's an eagerness for people to want this information. I do know that, Brother Zeinoul, you've mentioned that Awqaf will be running these sessions for the next, or once every quarter. We invite the beautiful speakers to come back and share some more of their knowledge with us. And then we definitely will keep people informed. Questions that have not been answered will certainly be made available on email. Our technicians have worked hard taking down all the questions, and we'll certainly post them. I think there are about 3 questions or so. That does require a lengthier response than what we can afford time to give us right now. On that note, I'm going to hand over to Brother Zeinoul to just give us some last closing words from Awqaf, which we have been truly blessed to be here today.
Jazakallah, Noorene. And basically what's the only thing left for me is to say Jazakallah to our panel of speakers, to Showkat, to Sheikh Muneer. You have really enlightened us. You have really come forward and shared your expert knowledge with all of us. It has been really very insightful and very beneficial as well, I'm sure, to all the participants as well. And we hope really, as Noorene said, to see you again, inshallah, on this platform. We hope to have further deep dives in various topics, and I think we've covered quite a wide range of issues tonight. But I think as we go forward, we can look at specific topics and go much more deeper into those particular topics. We will be sending out after this event a little email, a little form for just a bit of evaluation, and also any particular information that you actually require, and then we can then see, we can forward that to the relevant people who can provide us or provide you with that particular service. But once again, Jazakallah, you've been a wonderful audience. You've sent in a lot of questions, very, very interesting questions as well. And we hope that, this is just going to enrich all of us with the knowledge and confidence in dealing with worlds and estates, inshallah. Over to you again, Noorene. Jazakallah. And thanks to you as well, Noorene, for being a wonderful moderator. Shukran.
Thank you. Afwan. Jazakallah so much. Sheikh, I'm going to ask you to make our closing dua, and we will take our leave and bid our guest farewell.
And thanks to Hasanain in the technical side of it as well, Sorry.
Absolutely.
Al-Fatiha. بسم الله الرحمن الرحيم الحمد لله رب العالمين والصلاة والسلام على أشرف المرسلين سيدنا وحبيبنا ومولانا محمد صلى الله عليه وسلم وعلى آله وصحبه أجمعين. اللهم ربنا تقبل منا إنك أنت السميع العليم وتب علينا إنك أنت التواب الرحيم واهدنا ووفقنا إلى الحق وإلى طريق مستقيم ببركة القرآن الكريم. يا أيها الذين آمنوا اصبروا وصابروا ورابطوا واتقوا الله لعلكم تفلحون. وتمت كلمة ربك صدقا وعدلا لا مبدل لكلماته وهو السميع العليم. سبحان ربك رب العزة عما يصفون وسلام على المرسلين والحمد لله رب العالمين.
Rahmatullah.